version was probably from the Septuagint, not the Hebrew Torah. It was not in the Torah, but in the writings. And the word wisdom is translated in that version from the Greek Sophia. You notice the use of the feminine pronoun. And when I heard that, I thought, you know, wisdom, and I'm going to go ahead and get off on a tangent early on here. Wisdom in ethics, when it comes to making decisions and trying to think things through, we'll get into this on a slide, is often kind of a decision-making model that you notice is linear and very cognitive and consequential type thinking. But if you think about wisdom from the Sophia, the feminine side of wisdom, to me, and I'm a little biased here, it has to do with intuition, feeling, emotion, the parts of decision-making that traditionally have been neglected because, with the exception early of Carol Gilligan, who was Lawrence Kohlberg's primary doctoral student, the models were created or written by men. So no wonder they're linear or cognitive, you know. But that's not how we make decisions, is it? If you look at the body, there's more serotonergic receptors in the gut than in the brain, in the cerebral cortex. So if you think about some of the things you've encountered before in your practices and in your life that have to do with ethical, moral kind of decisions, your feelings are involved. Steve Binky, the PhD, JD, Masters of Divinity, almost became a priest before he decided to go into become a psychologist and a lawyer, talks about feelings neglected in decision-making models. So that's one thing I want to share with you today, because what I'm going to try to do is, for the Chattanooga students, I appreciate you being here. I didn't know you would be here. And someone asked me, can you talk a little bit about your philosophy of ethics? So I'll try to integrate that along with an overview of ethics for those of you that had it a couple years ago, along with some idea of the kinds of thinking and questions that come up on the National Counselor exam, along with some of the ways that that exam is different from the Comprehensive Preparation Counselor exam, okay? Some of you will be taking both, some either one. So just for an overview here, you know, and for the Chattanooga students, one of the questions that I get asked all the time is at conferences or where I go places and somebody sees me as a so-called ethics professor, they say, can I ask a question? It's a simple question usually, and then after 15 minutes, they have this very complicated thing, and they'll say, is that ethical? And it's like, as if ethics is a binary type of thing where it is either this or that. And I think of ethics in a dimensional way, where there is the ethical floor below which, if you fall, then state boards deal with it. And that's one of the jobs I've had for 8 years, and it's just an awful thing to see, to hear cases that are almost unimaginable. But then there's the other side of ethics that I think probably more represents where you folks are, that's aspirational, where you're striving to do what the Pharisaic Jews did way back 2,000 years ago, where they took the Torah and tried to live it as scrupulously as they could, even though it, you know, became more important than the ideas behind it sometimes. So we think of, excuse me for looking at here, but I'm trying to not look back at the screens. And as some of you know, I'm completely lost without PowerPoint. But the aspirational principles are really foundational, okay, the big ethical principles, and they represent things like the ceiling to which we strive, best practices, professionalism. Professionalism goes beyond ethics, goes beyond legal standards. Someone can act legally and ethically, but still can be unprofessional. Mandatory ethics, though, is the other side. It's what Cecilia Fisher, in her book, Decoding the Ethics Code, talks about enforceable ethics, which which I think when I hear this question sometimes, is it ethical or not? I think it usually has to do with that. Is it related to enforceable ethics? The mandatory ethics. Haas and Maloof in their book, Keeping Up the Good Work, use this distinction. I think they're the ones that introduced this idea in the 90s of mandatory versus aspirational. The ethical floor has to do with rules and regulations. As early practitioners, in a year or two, when you start working out there in the so-called real world, you're going to be faced probably most often with ethical dilemmas that you're not going to see coming, because they're going to be the things you don't worry about. They're going to be other things that are based on your lack of knowledge of a certain federal law, state law, we'll talk about those in February, or an ethical standard that's enforceable by the association or the board in which you have a member or a certification or license. That's where early practitioners get into trouble. Later, when you have 25 years of experience and become confident and become a specialist and know everything, then the ethical problems you get into there are very, very different, because you know the standards. Most of the complaints that are the most complicated to adjudicate on state boards come from people who are forensic specialists, which mean they know the law, they know the rules, but they're so great that they know everything, and they practice with one of the 7 deadly sins that many people think is the cardinal sin, with a capital T, because all else hinges on it: pride, arrogance, overconfidence. Arnold Lazarus, who I got to talk to when I was in graduate school before he started writing in ethics, talked about greed as being the main ethical problem. I still see that. Another one is, from Lazarus's perspective, is not consulting with someone else. Let me go to the second slide. You'll be happy today. I've only got 10 slides. Isn't that amazing? Yeah. Any questions or comments or just thoughts that you have? I saw a new client actually last week who came in and talked almost nonstop for 2 hours. And when I started kind of getting a little bit of a history, kind of unobtrusively, the person said, well, I did see someone else last year for a month or 2. And I said, oh. I said, before I could even say anything, the client said, but I don't think it really went very far, because I was just peppered with questions the whole time. And I thought, oh my gosh. I said, well, am I asking enough questions today? Do you have any comments so far? I want to allow some time for that. Okay. Yes, Laurie.
I just find it interesting that I took your ethics class 2.5 years ago and was kind of inundated with it was very scary, very, very scary. And now being at the end, applying those principles, it just takes on it was very 2-dimensional. And now ethics is, because we've been in front of clients, it's very 3-dimensional, and it's even more confusing at times and scary at times. But I do feel like it's a great. I wish I could I guess I am taking a little course again, but I mean, like at the beginning of internship to kind of remind us. But it's really taken on a life of more 3-dimensional.
Do you hear that? Do you hear what she's saying? It's interesting, because it's like the lion that's saying, I'm scared. Well, think of how Gunther Gable Williams felt when he went into the cage with 12 of them. It's scary for me too. Practitioners that, oops, sorry, I think Philip was supposed to sit here. practitioners who are scared that they're going to make a mistake usually don't. They're usually, in my experience doing training for about 40 years and on the state board and ethics committees and stuff, that's usually not where someone gets into problems. Because if you're scared, what do? Usually? You go cautiously, right? You watch your steps. Well, one of the 7 cardinal virtues, actually. Diligence counterbalances the sin or the vice of sloth. What else do you do when you're scared? Ask someone. Yeah. Like if you hear a sound outside and you look over, even carnivores do this, they do head checks. Primates do too, primates actually. They do head checks because they want to, did you hear that? Let me check it out. You're going to have colleagues with whom you consult. One of the things I get to face on adjudication of complaints, learning ethics, kind of the ways physicians learn to practice good medicine. They look at how people die and they look at diseases. It's a weird way to study health, isn't it, to look at it from the bottom? But some of the cases that I've adjudicated, when you listen to what happened, you think, what were you thinking? I mean, it's the kind of stuff I would ask one of my nephews when they were teenagers. Well, they weren't. They weren't thinking, but they also were not just checking it out with someone else. And they certainly were not scared. NCE question. You might have NCE questions that require you to make decisions about things like aspirational versus mandatory ethics, that type of thing. If you prepare using the NCE practice guides, the purple books, and all that kind of stuff, you very likely will help raise the school's national ranking on the percentiles, okay? So I wouldn't worry about passing it. I would worry about setting a high score. It's kind of like when I was doing the dog training stuff, we didn't worry about qualifying, we worried about winning or, you know, getting up in the top. That's what you'll do. So you'll study that, and this will be the kind of thing you might have a question on. Let me ask you a question here. Now, this is something that I don't focus much on ethics class in the classes I teach, because I teach ethics from an interdisciplinary perspective usually. I'm kind of a little biased towards the legal risk management angle. Do you know the history of the American Counseling Association, where it started? Interesting. Virginia. What was unique about Virginia? In what year? 1976. Very good. Same case, the same year actually that the Virginia Blues case was decided by the United States Supreme Court. Another thing though, in Virginia, I'll let it get my stomach here on the camera. Oh, thank you. Virginia, 1976. You know the last date? That is something you might have on the NCE type question, which is the first state for licensure, and it might be, you might have an answer like that. They're probably not going to ask the year. Last date was California, 2009, mostly because of the strong, I'm giving some opinions here, and I don't like being recorded because I do better on paper, have time to give citations. Probably because of the strong lobby of licensed marriage and family therapists in California that took so long for that state. How about Georgia? For licensure, when does it go back to? 76 to 2009. Some studies say that some surveys say there's 35 different practice titles used in different states in this country. Others say there's about 54. My estimation is probably a little higher than that. Depends on how you're counting them too, whether it's for independent practice or whether it's for limited practice with supervision. So a lot of different titles. Georgia, in 1984, the General Assembly created a composite board, and in 1985 appointed the first board members. And the first board members were actually given licenses. And then the first licensees were, I think it was December 1986. This is about 10 years after Virginia. Okay. In the 50s, the Soviet Union launched a satellite, Sputnik. Yeah, you've read this. This could be a question that you could have on your NCE. Which of the following historical events founded the... Because of that, the United States thought, oh my goodness, in this arms race, the Soviet Union was ahead of the United States in graduating people with science, technology, engineering, mathematical degrees. They graduate, go work for industry, not in public schools teaching. The United States created the National Defense Education Act to quickly get more high school students taking math classes. You still can't do this. And getting more people to go back in teaching math and then to be in these technology areas. Who are they going to get? Who are they going to get is these guidance counselors. They got school teachers and they trained them through the summer so they could become vocational and guidance counselors so they could track people into what we now call STEM areas. Okay? So that's really one of the early origins of counseling in this country from the 1950s. Some of it goes back before that because the National Vocational Guidance Association is the original organization. These are some of these groups that when you see them on the test, the NCE, you say, why are they asking about groups? 2 years ago, I remember when the students came out of the NCE, they said, there's so many questions about groups. We didn't cover groups. And I'm thinking, gosh, is it my job to cover groups or who teaches groups? But they were talking about these kind of groups. The American Counseling Association, the National Vocational Guidance Association, and 3 other organizations got together in Los Angeles, California in 1952. And they formed another organization that's called the American Personnel and Guidance Association, okay, that was basically the predecessor of ACA, because in 1992, the American Personnel and Guidance Association simply changed its name and it became basically ACA. So that's where that comes from. Those are 3 organizations that might be good to kind of know something about for your test. The American Association of State Counseling Boards is not an association where you would have membership or even want it. Its members are the members of state licensing boards. So if you went to one of their national conferences where they have those, it's just geeks that are talking about the minutia of licensing board rules and administrative law. It would be worse than this session today is. The National Board for Certified Counselors, you see, goes back all the way into the early 80s, 82, because at that time, think about this historically. We don't, I mean, you know, the reason I'm teaching this today, or I'm not really teaching, but just talking to you about it, you're the future. But to best know where you go, it helps to know where you've been. NBCC started out because there were no licensing laws, except in just a few states. So how do you know who's really competent? And that was the way it started. I still think it's important. I never refer to a LPC. Well, I refer to them when I'm gossiping, but if I'm referring a prospective caller, I never refer to anyone who's an LPC unless they also have a NBCC certification, a National Certified Counselor, okay? It's just an additional level of competence. Sure, they cannot be competent, but at least they're doing what professionals do to try to fit in the mainstream. KCREP is not something you'd have a membership in. KCREP does not provide memberships to individuals. It simply accredits training, sections of training programs, okay? This is currently a KCREP program. The reason it is important is if we ever move to what's called portability or mutual recognition in terms, and this is the future that I know you don't care about, but you will eventually. The American Association of State Counseling Boards, this is what they care about. This is what you will care about if you ever move out of Georgia and want to get licensed in another state. Yeah. It helps to come from a KCRA program. Let me just leave it at that. Questions, comments about where we are right now on this? Half of your ACA members are actually school counselors. That lets you know. So actually, if you look at the budget that came out of the executive budget that came out for the federal government back in the late spring, the reason counselors went so nuts about that, which I think they should have gone nuts about it, is because it was going to basically gut school counseling programs. Well, if you do that, then that means if you think about it only in terms of economics, counseling economics, it means there's a lot of potential jobs out there that are no longer available. And then they're going to be competing against you, okay? That didn't sound too political, did it? Those kind of things swing back and forth with administrations. You see a lot of that over the years. That pop-up just basically says what I was saying, in case I completely forgot everything. One distinction that you might have remembered earlier that relates to competence has to do with certification, licensure, and then the limits of licensure and the limits of scope of practice. Certification, as you know, is voluntary. You don't have to get board certification. I just had to pay, I don't know, probably close to $1,000 in board certification fees for the boards that I'm certified on last week. And it is just a big royal pain. And I'm thinking, why do I keep doing this? Well, it helps if you're like me and you're only going to refer to LPC and NECs, National Certified Counselors, NCE, I'm sorry. Or in my profession, if you're testifying in court, then certifications matter. Makes you look better, look like you know what you're talking about. State agency certification is a question. You might have something about that on your NCE. We don't talk about it much, but state agency certification is this. It means, like, take school counselors. Cobb County can have school counselors. Cobb County is where we are right now in Chattanooga. They can have public school counselors, but they can make up, because they're part of the state government, they can exempt them from having to be licensed. Does that make sense? So the state agency itself provides a certification that means they can practice in the agency. This used to be a common way for people to be certified and practice. When I did an ethics workshop for the Clayton County school counselors a couple years ago, out of about 100 people there, I think 20 of them were state agency certified counselors, and one was a state certified psychologist, meaning they didn't have licenses, but they were certified by that county to practice counseling, okay? What that also means, though, this would be important, if you decide not to get licensed, it means you cannot practice outside of that state agency, or if you do so, you're doing it unlawfully. Does that make sense? I'm not talking about that too much. You don't have to get licensed either, but you legally can't be practicing without a license. Licensing laws, back at the time Virginia became the first state in the 70s, were what we call Title Protection Acts, and they still are that way. The Title Protection Act means the state law protects the use of that title. So if the composite board gets a complaint that someone's practicing counseling and they're not licensed, if the composite board wanted to, what they might do is pull up the person's website, and if it said on their professional counselor or providing counseling, then they would be holding themselves out to the public if they didn't have a license, without a license, meaning they're using the title illegally. Does that make sense? Now, if you think about it, you'd want a state law that's actually more stringent than just protecting title. You'd also want it to protect the actual practice of a profession. So pretty much now all state licensing laws are practice protection acts, meaning you can't use the title, or you cannot practice the profession, either one, unless you're licensed. Now, another area is what we call mobility, or the technical term that we're seeing. This is a new area. Well, I say new, I mean, to me it's new. It's been out, it's been in the press for about 5 years on the state boards. It has to do with what some people call reciprocity, which is not a really good term because that does not exist except with state driver's licenses and things. It has to do with being able to practice in another jurisdiction without being licensed in that jurisdiction. Think about that for a minute. I'm licensed in Georgia, but I want to, and maybe I have an office in, let's say, Ringgold or whatever's up 75. And I also want to have another office, like a satellite, in Cobb County, and maybe one up in Chattanooga. But I can't have one in Chattanooga unless I'm licensed in Tennessee. You follow that? Okay. So I can get licensed in the other state. In fact, I got a letter recently or email from someone who's licensed in, let me not mention the state, this is a northeastern state, has a student who's moving to Georgia and wants limited practice in Georgia without having to apply for a license, and so is notifying the board. So my opinion on that is, no, you can't practice in Georgia unless you have a license in Georgia, okay? Doesn't mean you can't do it, but it means it's illegal to do it. Just like it's illegal to drive, as I found out once, 98 miles an hour on 285, but you can still do it, right? It's just illegal, and so if you get stopped, you pay the penalty, yeah.
How does this work with the new telemental health certification?
Well, that is why, oops, sorry. I'm going to be really bad when I get in the nursing home, I can tell, because I'll keep wanting to get out of bed. I'll be one of those they have to restrain. Telemental health, or in Georgia the term is now telecounseling, telehealth, telemedicine's been out since the 70s, actually, Vietnam War, the surgeons did that. That is the impetus that makes state portability so important now. That's what's driving it. It's not setting the office up in another state. It's interstate practice using telemental health. At this point, if I have someone who's a resident of another state and I'm in Georgia and I'm providing telemental health to someone in that other state, and this is actually a federal and a state legal question, and it's an administrative law question, so I would defer to any state attorney general on this, or usually the assistant AG, or a lawyer, because it's a legal question, right? Why ask a psychologist about a legal question? It would be illegal for me to do the telemental health with someone who's residing in that state unless I'm licensed. Now, then who wants to do that, right? Now, some states, including Georgia, for the composite board, and also the psychology board has done this, have actually created licensing board rules that allow what you're calling telemental health intra-jurisdictionally. Now, what does intra-jurisdictionally mean? Does anybody know that? Yes, inside the jurisdiction, within the state of Georgia. Okay, well that's good, but it still doesn't address the problem of what about that client who's in Tennessee and living there, and then we want to do the video conferencing with them. Legally right now, that's not allowed under either state law. For that to be allowed, what we're going to have to do, and this is being done, is to have portability. Let me see, here's where my memory goes pretty bad on me. Kentucky, Illinois, and West Virginia, and one other state right now have what's called, to use a legal term, an interstate compact, C-O-M-P-A-C-T. An interstate compact, and this goes back to federal constitutional law, actually. The federal government cannot interfere with states' having interstate commerce, right? I mean, otherwise, why would Walmart have distribution centers in Georgia? It's a national store. It's an international company, right? So they can sell between states and among states. So an interstate compact is an agreement. It's basically a contract or an agreement between either states or state boards that they will recognize a license in another state. Now, nurses have been doing this for quite a while, for about 20 years. Nurses are way ahead of all the other professions. Nurses use a model, and there's several models for handling this. One model is called mutual recognition, where boards agree to recognize each other as having proper credentials for licensure in that state, and we'll let you practice in our state too, as long as you have those credentials and as long as you pass a jurisdictional or a jurisprudence legal exam. Think about the differences in the laws of Tennessee and Georgia. They're actually very, very different in the area of counseling and in medicine. It's real big differences, as you can imagine California and Tennessee would be. Well, if I'm going to be practicing in Tennessee, I need to know the laws, don't I? I mean, to the extent that they relate to me, like mandated reporting, for example, what the differences, those kinds of things. So maybe Tennessee is going to want me to take a jurisdictional jurisprudence exam just to show that I know the laws there. And then everything else is cool because I got a Georgia license. And that's what we call mutual recognition with a jurisprudence exam. Is this making any sense? Okay. Now, another way to handle this, though, is to have what we call endorsement, which is the term we use here in Georgia. Endorsement is what some people also call reciprocity. It doesn't really mean reciprocity. It means someone who has a license, let's say in Virginia or Tennessee, can apply to the Georgia board. And because they already have a license, that will eliminate some of what they have to do to get licensed in Georgia. It makes it easier. I have what's called an interjurisdictional practice certificate. I'm also double board certified. So if I send that to another state, I could be practicing almost immediately. So there's some credentials that allow that type of endorsement. Not really reciprocity, but endorsement. There's another way to do it. It's what we call limited duration practice, and most state boards have this. Let's say you have a case where you have to go to Tennessee and testify in court on a domestic dispute or child custody or something like that, and your clients were in Georgia, but there's somebody in Tennessee now, so you got to go to Tennessee and testify as an expert witness or something. Follow that? Okay, not a fact witness, but an expert forensic witness. Technically, if you do that and they're qualifying you on the stand, they're going to ask you if you're a counselor, right? And if you say yes, but you're not licensed in that state, you're practicing counseling in that state without being licensed. So how do you get around that? I mean, you start thinking like a counselor. I would write to the state and ask if I can have a limited duration practice privilege or visitor, what they call guest privileges. And the state can acknowledge that. I'd have to send them evidence of my Georgia license to show that it's active and clear. And that might be all I have to do. And then I can go to that state and do that. Okay, that's how it's done, actually. And actually, we're seeing in the forensic area, can you imagine this? That's where state boards are getting a good many complaints now. They're getting complaints by attorneys related to forensic expert witnesses who are not licensed in the state where they're giving the testimony. And if you think about it from a legal angle, it's pure legal strategy to try to get one side out of the case. Now, there's some other ways to do portability also, or mobility. This is a topic we didn't, probably in Chattanooga and Atlanta, you didn't hear much about in ethics, but for you people, it's the future of that. It's the future, I think, a lot, because you're going to be moving and it's going to really matter. Or maybe you're not going to be moving, but you're going to be doing mental health. And I can't talk about this, but there's actually a practice in Georgia that provides that all over the country right now. And it's kind of controversial because is that legal or illegal? Federal licensure. How do you like that idea? You do? Okay. then I know which way you vote. And I'm not a registered voter, so I can, I guess, say that. Federal licensing means that the federal government gives the license out and administers the license. So we don't really have that in hardly any area right now. That would be a little unusual, and for some people that would be a little creepy. There's another thing called national license. National license means the federal government gives the license. Once the person has the license, the state administers the regulation of the license. You like that a little bit better? Then I know where you are politically. Okay, so you have federal license, national license, mutual recognition, and you have endorsement. And then you also have guest privileges. Do you follow those? Thank you for stopping this and having a good comment. Go ahead.
I'm just curious, is there future development towards being able to do international telecounseling services? And what was that? Would there be reciprocity if you're, licensed to be able to offer counseling to someone who's living abroad?
That is a really great question. And I have no idea. I can tell you, though, that is presenting a dilemma to some state boards in this country. This is the kind of stuff, remember that association I showed you that was the membership organization for licensing board members of different states, and then all 100 of those people get together every year and they talk about all this. This is the kind of stuff they talk about. That's a problem, because what if I'm doing the telemental health to someone who's in China? This is a real case. Well, that's China's business, right? That's China's business. So the state board really can't regulate what's going on over there in China, right? Yeah, or the UK. And so in a way, that is something that state boards cannot regulate the way that they can regulate interstate practice that way. So actually, if you want a loophole here, you're actually safer doing that probably legally. Have you ever been in a prison in a foreign country? Okay. You don't have some of the same rights that you would in this country. I can say that from some experience. So interstate license is more easily regulated, because this way here's how it happens. You're licensed in Wyoming and you're doing telecounseling, and someone is in here in Georgia, and the Georgia person has a problem. Let's say they become suicidal, they get hurt, and then somebody in the family says, well, wait a minute, that counselor should have done something. Who's that counselor? Well, the counselor's in Wyoming. So they file a complaint, okay? They're gonna file a complaint to who? The Georgia board? Yeah, they file it with the Georgia board. That's all they can do. The Georgia board will immediately, theoretically and legally, they will administratively, this is what they should do, they will send that to Wyoming. Okay, so that's how state boards work, and that's what that association is about. One state board finds them, and that's what we do here in Georgia. If someone in Georgia is hurt, what we do is if the person's not licensed here, we send that to the other state. Now, the Georgia board can also do this. They can issue a cease and desist order, and actually that comes from the Georgia law office. It's called C&D, and then the Attorney General serves them with a cease and desist, and then that goes as a public record. Nothing happens though, but they get a C&D. Now, something can happen though if they get a second complaint, because if someone has a public C&D and then a second complaint comes in that the person's practicing, and then there's some evidence that they're practicing, they go to an administrative law judge, they can prove that, then they can take the C&D and they can say they violated that, and then they can put them in jail. Okay, and that's kind of what happens next. It's not very common, but that's procedurally what happens. We got one of those in Georgia right now on the, I won't name the board. It's not either one of the boards that we're talking about here. So intrastate practice would be practicing within the state. Interstate is among states. So learn as much as you can about reciprocity and endorsement and mutual recognition. Mutual recognition, I think, is the model that I know counseling and psychology and certainly nursing were way ahead using mutual recognition. I tend to favor that one, but that doesn't mean it's right or anything. That probably means it's wrong. The American Counseling Association and some other, Actually, ACA does have a model for this. They have a endorsement model, and some other organizations have one. To me, these are pretty lean. The ACA model that just came out in the December counseling today is a very, what I would call liberal, lenient, not stringent enough model that basically says if somebody's licensed in another state, then they can be licensed in this other state. I'm thinking, yeah, you want more than that. You want like a jurisprudence exam and some of that. Those terms here are the kinds of things you might see on an NCE question. Not this geeky stuff here, but this is for you the future. Licensure. Let me say one more thing about licensure. Let me see. Once you have a license, don't let it lapse. Don't let it lapse, and if you ever decide you want to quit practicing, then you place it on inactive status. Okay? Like, let's say you have, who's this recently? I saw somebody had like 15 different state licenses. And now, for that person who's a forensic specialist, they'd be a lot better off if we have mutual recognition. They could have one license. By the way, if you work in the military, and there's some controversy about this, but possibly VA hospitals, most state boards are fighting that part. But if you're a military counselor or psychologist or mental health professional, you only have to be licensed in one jurisdiction in this country. And then you can practice on any base in the country or internationally. Does that kind of make sense, doesn't it? In a way, that's like state agency certification by the federal government, right? Because they can do what they want to do. The problem with that is this. These people who are licensed this way, what would you do? You would probably get licensed in the state that has the lowest qualifications, and that's typically what they do. Then later, what if you want to get licensed in another state because you're out of the military, you want to set up your office? You might not be able to get licensed in other states that have more stringent requirements. You follow that? I see that problem a lot, and there's two states where it happens a lot in. One has the lowest standards, one has the highest standards. Don't ever let your license lapse, because the longer you're out of school, and I see this happening with people that have been practicing 25 years. The first 100 people that were licensed by composite board all lapsed now. And think about it, they were licensed after I was licensed, so they've all lapsed. Why is that? If you want to get licensed again or reactivate your license once it's lapsed, what you've got to do is you've got to do what you're going to do in 3 years. You've got to start all over. You got to take the national exams. You got to get letters from your supervisor. You got to do all that from scratch. Why? It doesn't seem fair. Because you don't have a license, right? With administrative law, it is as if it had never existed. So that is also one of the reasons to get certification and stuff like that, because it increases the possibility of portability even for people that do have a lapse. The times that I have brought these to sessions are times when I have had to deal with people who've been practicing for 20 years and moved to another state and moved back to this state, and they had let their Georgia license lapse, and they are so ticked off that they've got to get a new license from scratch. Now think about this. They're also, the licensing board changed their requirements for licensure. So in September 2018, this year, 2018, those standards will change, and they're more stringent than they were for people licensed even right now, or even in August. And that keeps happening. Boards tend to become more stringent and more conservative. This is awful, isn't it? I mean, what comes to mind when you think of boundaries? Huh?
Safety.
Safety. Protecting the client.
Protecting ourselves too. Yeah.
Protecting yourselves, but you protect yourself by protecting your client, right? Your first duty is to protect your client. That seems right, doesn't it? But it's actually wrong. Binky actually, Steve Binky, I like to quote Binky because he's a great ethicist notwithstanding some of the things he did with the Department of Defense that got him into trouble with the American Psychological Association. But that's another matter because we were in a war that has lasted, I think, now 16 years. Safety. Most counselors, according to Binky, who get into trouble not because they were wanting to do bad, but because they were wanting to do good. They were wanting to protect their client. I've had counselors that I've talked to that had to be dealing with the FBI for interstate transportation of minors simply because they took a child that was being abused and they took that kid from the office and they babysat with them for an hour before DFACS could pick them up. Well, you know what? That's kidnapping. And if you drive from, I'll make it up here, across the state line from 75 into Chattanooga, that's interstate transportation of a minor, and it's illegal. What were you thinking? I was only protecting the child till her auntie could come pick her up. So be careful about, I think my role is to provide a safe place, like QT does, right? To provide a safe place. But when I think about protecting my client, and I advocate protect myself by protecting my client first. Safety. Safe boundaries come up with that. Safety. What else?
I have a quick question on that, because I live in a neighborhood where you drive in and out of the state.
Mm-hmm.
So you're saying that if almost if you live in Chattanooga, you almost need a dual license, because Chattanooga's on the Georgia line.
We're hypothetically here.
I live in a neighborhood, literally, you drive in and out of the state to get to my house. You drive in to Georgia, you flip into Tennessee, you go down the street, you're in Georgia, and now you're back in Tennessee.
I understand that. Literally, where is your office address?
But I don't
where you see patients? Then you don't need to worry about that.
But I will.
Okay, then where literally will be your office address?
I'm at in Tennessee.
Okay, then you need to have a Tennessee license.
But what about the Georgia people who live down the street?
Who see her in Tennessee?
Correct.
She needs a Tennessee license. Don't take my word for that. Write to the Tennessee board or the Georgia board and get a legal memorandum from that board on that. But my opinion, as one of the people who gets together and writes these things, would be that you need to have the license where your office is located. Does that make sense?
Yes. Yes.
Yeah.
I just wanted clarification of that.
I had a client that came into well, this doesn't make it right, but I have clients that come in from other states to sometimes see me in my office in Atlanta. Why would they fly or drive so far to do that? Well, they might or might not want to, big deal. I have to be licensed in Georgia to see those people, right? Doesn't matter where they're from. Does that make sense? Now, here's where you'll get into a little bit of a problem. You like to learn from my mistakes, don't you? What if you have a license in, let's see, Sandy Springs, or Fulton County, Sandy Springs, Georgia, which is Fulton County. It's where 285 and 400 hit. What if you have a practice located right there? So you have to have a business license. You have to have a license to practice, but you also have a business license. This is an area, by the way, that I see really, really neglected by a lot of psychologists, few psychiatrists, a lot of psychologists, and almost, not all, but most counselors. They neglect to have business licenses in the jurisdiction where they're operating a business, okay? Psychologists do too. In fact, I've known pretty prominent ones that do, but that's none of my business. My business is to make sure that I'm licensed to practice my business in the jurisdiction that I'm in. So for years, I had a Fulton County business license. I think it was 2008 or so, I forget the year, but the city of Sandy Springs was proposed under the state legislature to be its own city. You follow that? So they became a city. I'm still in Fulton County, paying my business license, doing my net worth property taxes for Fulton County, because that's where my practice is located, all right? And then I'm at a state board meeting one day, and we're handing out the Kleenex because someone comes in who's lost a license because it lapsed, and they're trying to get a new license, and they got to start over again. and they don't like this idea of $4,000 of fines and a C&D and have to notify every insurance company that they were on, that the patients they were seeing when they did not have a license. Think about that. You ever had to pay back $120,000? Yeah. I mean, these are terrible. And if you're a Medicaid provider, you ever spent 10 years in a federal prison?
No.
You follow this? So I'm thinking, is my business license current? I'm thinking, yeah, I did it last January, and I'll pay it like I do every year. It says, no, I didn't get something back from Fulton County last year. Then I start thinking, well, I'm still in Fulton, but I wonder if this is part of Sandy Springs. I think I'm right on the line. Well, actually, I was right on the line, but my office actually was part of annexed Sandy Springs, so I was in Sandy Springs. So Monday, when I get back from the board meeting on Friday, I call Sandy Springs tax department. I say, here's my office location. I said, am I in the city of Sandy Springs? And they said, yes, you are. And I said, do I need to have a business license? They said, yes, you do. And I said, oh, okay, here. I said, well, I don't have one, and I've been practicing here for the last 4 years, and I didn't know this was, I didn't know that I couldn't go 98 on the expressway, right? I said, what do I need to do? They said, you need to fill out a form, you need to pay for the business license, and then you're going to need to pay penalties and interest for the years you were operating a business there in which you were unlicensed by the city. Not a big deal, it's $400 a year. So it was like probably less than $2,000 or $3,000 that I had to pay. But still, think about what a pain that was. Now, what about this? Because my home is 7 minutes away in Dunwoody, which became a city a few years ago. I get some of my mail sent to my home address because the mail is more reliable there than it is at the office address. Do I also need to be licensed at my home to operate a business there? So how do I find out? Well, best way to do it is to write, but instead I call the city of Dunwoody, done it 2 or 3 different times, and I've talked to an attorney several times. No, you don't need to be licensed unless you're practicing your occupation there. No, I'm practicing it here. I don't see any clients in my home. The only thing I do is get a few tax kind of things sent to me. But I said my federal corporate tax stuff does have my office address on it, not blah, 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 blah. Okay, no, you don't have to be like, but what if I decide to give up that office in Sandy Springs and move it over a few miles into Dunwoody? Then right then I have to start getting that new license for a local jurisdiction license. That's different than a professional practice license. Is this information useful, or is it just a meaningless story I'm telling? Okay. Trying to think of the feedback I got last year. Yeah.
So I learned out of a group private practice. The private practice itself has a business license. Do I need to have my own?
What jurisdiction is this?
It's Gwinnett County.
I would ask, that's a county. They have a county license?
Well, it's the City of Grayson.
City of Grayson, they have a City of Grayson business license. I would ask the tax clerk of the City of Grayson. I would actually, if you want a really good answer, I'd write them a letter. Oh, you know the answer?
No, I would.
Oh, move it. Oh, we're getting bogged down. Yeah. Yeah, ask the tax clerk. I'm sorry. This stuff will matter to you later. Yeah, it'll matter. Boundaries. Okay, I think of boundaries different ways. Think of time boundaries, like keep it moving. The section's rolling over too long. Thank you. No, I need some horses in here for the psychopathology class, because we'll definitely do that. This is in my book. Those of you in Chattanooga have read this before. Okay, I'll just skip this slide then. Boundaries. Although it's the most important thing in ethics, really, because competence, disclosures, everything is related to boundaries, is it not? Everything is. Touch. I had an old client that came, not an old client, but a young client, because to me, everybody's young now, who came back into my practice a few weeks ago, and it's someone I had not seen in years. And she came in, I went in the waiting room, and I said, and I thought I was almost going to hug the person. I thought, wait a minute. And she was a business person. We shook hands. And I thought, for that particular person, it probably would have been okay to touch that way. It was public. There were witnesses. there would be no misinterpretation of what was happening. But you never know, because when you're on a state board or you're on an ethics committee and you hear things that happen in people's practices, you think, well, that doesn't sound like anything wrong, but boy, a year and a half later, the client now sure thinks of it in a different way than they did before. Talking about touch, self-disclosure. The Emory Psychoanalytic Training Program, they used to say, if I'm saying anything about myself, I have said too much. If I say two things, I'm not even doing psychotherapy. I'm the patient, basically. Be very careful about that. Think about the self-disclosures you make in sessions, even impact statements, how the client impacts you. Think of those, of what they will sound like when the client reports those to someone else who was not in that session. And they take one little, I have to deal with this in class too, you have to deal with it in class. One little sentence of what you might have said out of context, put in a different context, and it sounds completely awful. You think, oh my gosh, I wish I never said that. Well, you didn't mean it that way, but then that's how it's put. So be careful about self-disclosures. Those are very hard to justify when you're adjudicating a complaint. Context where you're practicing, your attire, boundaries, keep it moving on here. This is the kind of thing you're probably not going to see on an NCE question necessarily, but you might see it more on the CPCE, where it's a more deductive reasoning, kind of problem solving, thinking about things test. Again, your prep guides are going to really help you through those. I tell you what, when I took my board exams way back, and it's still this way because I review the stuff, you know, for people, I look back at those review books, and back then they were like binders you could get, and they would be like this thick, and I took like 3 or 4 months just work through that stuff, you know, like an hour or two every day, work on my weak areas the most, just like bodybuilders do, and, you know, race car drivers work on that. You know, by the time I blew the top out of my national exam for licensure, I thought, you know what, I thought a smart person reading only that material could have eliminated 7 years of graduate school just to pass an exam. And that's how these exams are. You'll think this stuff doesn't relate to how I work with clients. No, it does not. It just it relates to things that can be measured. Here's an important one. What we used to call a release of information, which is no longer even a term, is now called an authorization. It means an authorization for the disclosure of protected health information. Even if you think you're not a covered HIPAA entity, you will be judged on the basis of those federal standards. If you do any texting, or the client that came back a week or two ago emailed me, and was nice enough to have a phone number there that matched the original number I had. And then I checked the person's date of birth on the phone call. As soon as I returned a call, I did not email, because even though I'm a covered HIPAA entity, I don't do electronic transmission work, because if I do, I've got to go through a whole nother series of things to be in compliance with HHS requirements. Authorization for disclosure. It has to be signed in writing by someone who's a legal representative of that person. So it can be an adult person, unless they've been adjudicated incompetent. If they have not been adjudicated incompetent by a state law judge, then they're competent to execute forms, okay, such as an authorization to disclose information. A parent of a child, and also a guardian, in some cases a guardian ad litem or a custodian. Okay, so I'll always, if I'm seeing children and the parents, let's say, are divorced, I always want to have the child custody settlement, and I want to see that in my office, the most recent version of it. Otherwise, how can I make decisions? And I've seen several cases like this in the last year, where the person who was bringing the child in, who was a parent, didn't even have the legal right to consent to the child being there. And then the other person wants all the the other parent wants all the records. Can they get them? Yeah, they can get them. And besides, that's the person who you should have gotten the permission from. How'd you miss that? Because in the legal section of your patient chart or your client chart, you didn't have that information from the custody agreement. There's certain mandatory disclosures, such as mandated reporting of child abuse. Tennessee has a very broad law compared to the more circumscribed law in Georgia. For elders, which now is anybody over 65, and for disabled people. And disabled people doesn't just mean someone who qualifies under ADA because they have attention deficit disorder. If you read the state definitions of disability, it's actually pretty severe, and it's designed mainly for people who are in what we used to call nursing homes, people that really can get exploited. Tennessee and a few states also have mandated reporting of what we call the Tarasoff Doctrine types of cases, and even cases when people have contagious diseases that they could be spreading to others if they haven't forewarned those people, and Georgia does not. So that's one way that Tennessee and Georgia are very, very different. We might talk about that more in February on the legal part. That means if I have offices in two places, my consent form and what I talk to people about is going to be really, really different. And you're governed by the laws in the state where you're licensed, where you're practicing. And you shouldn't be practicing unless you're licensed there. You're not governed by the law of where the client is from. So if the client's from Arizona and seeing you in Chattanooga, you're governed by Chattanooga law. Keep in mind, here's a way to save yourself some money. A subpoena compels a response. You have to respond to a state subpoena within 10 days. I'm sorry, 14 days, federal within 10. It compels a response, but not a disclosure of PHI, protected health information. So if I receive a subpoena from a law firm, I have to respond to it, otherwise I can be held in contempt. But my proper response would be to release the information if I already have an authorization on file, which in the cases I used to work on, I already had the authorization signed, so when I got the subpoena, just said, here's the stuff. If I don't have the client's authorization, then the proper response to a subpoena is, first of all, to notify the client, find how the client wants to guide you on this, because the client might say, oh yeah, I forgot to tell you that was coming, and I want you to send the records. And you say, well, I need a signed authorization. Oh, you can just send them, it's okay, it's my lawyer. No, I can't do that, you got to sign. Because they change their mind. How do you know it's their lawyer? Okay. If the client objects to the release of the information, though, then what you do is you file a motion to quash the subpoena, and you can do that in the county. So I do it in Fulton County if I want to file a motion to quash. And you also send a letter to the other lawyer or the person who's issuing the subpoena, basically letting them know that the person is a client and that the information they requested is protected under privilege, and therefore you cannot release it without a signed authorization or court order. And since Jaffe versus Redmond case, and when was that case? I remember this one, 96. That's a long time ago, isn't it? Yeah. Since then, you don't usually get courts ordering these kind of things anymore. The only time you get those are on capital cases where the forensic examiners already had a court order for the examination to take place in the first place. You can get some of this on a NCE questions. Decision-making models. This is one of the big ones used. You might have a question. These models, you know, one of the things I hear about the ethics class that I teach at universities, and I hear this later, is that people find the models we use so useful. And I'm always surprised by that, because the feedback I get sometimes implies that wherever they are in their internship or where they're working, that people don't use some type of systematic approach to making a complex decision, which I can't believe that. But remember, you always start with identifying whatever the problem is. Your likelihood in a decision-making model in the next few years of practice would be a decision-making model that focuses a lot on what is the standard, what is the law, what is the rule, what is the ethics code, or what does it say? When you become experienced, usually you already know that. You know those things, and you consult with someone on a different level. The model, so this is the kind of thinking, if you think through things, this is the kind of thinking you need on the CPCE test. And the decision-making approach that I kind of put in my books, and I think this is one I've used with people over the years when I've done consultation, is start with identifying the client. I am amazed. I'd say 80% of the consults I get, the client has not even been clearly defined. And it's like, well, that's creating a problem right there. Is it an organizational client? Is it this person? Who is the client? Identifying that, and then knowing what the standards are that apply to that particular situation. Now, theoretically, I want to know all this in advance, right? I establish who the client is, who it isn't. Thinking about options, thinking about consequences. Consulting, really, really good practitioners don't even always think about consultation with a colleague because they have maybe a 2-hour peer consultation group every week where they're constantly just going back and forth talking about things that are concerning them. So they're constantly doing that. If you're doing that, fine, that's all you need to do. That is consultation. That's why many state boards now, some of them here in Georgia, will give CE credit for that because it's very valuable. Those practitioners stay out of trouble. But when you're in a complex case, document that in your client file also, okay? Just document that you brought that up during the case conference and that you consulted about it. Some of the biggest legal cases I've seen here in Georgia have consultants where their own notes of the consultation contradict each other. Or I've seen some cases where somebody consults with another person and then you pull the file and they don't even have a note of the consultation ever taking place. You think, well, did you do it or did you not? Really conscientious practitioners that I get to talk to that are big hospitals like Grady or Emory University or Ridgeview or DFACS, Secretary of State's office, the questions that they often raise imply that they're trying to do the right thing, but they're in an agency where they perceive something going wrong and they don't feel good about it. And that's why I think Mark Homan's model is so valuable, because Homan deals with what do you do when you're working somewhere and something's going on that you think is illegal, a felony, or it's unethical. Then what you do is, well, you learn more about it first, because some things, if I learn about them, I realize, oh, this procedurally is how it works. And then I change my perception. There's really nothing wrong here. It's just I didn't understand how the rules of the law work. I also can identify it as being unacceptable, but I'll just do what I can to be there, accepting the unacceptable, if you will. I can join a committee, or in my case, join a state licensing board, and then 5 years later, actually get one rule that gets to the Georgia Law Office and make changes. That takes a long time. You know, I used to do workshops in the 90s on how Georgia needed a duty, a statutory immunity for duty to protect when we make a terror assault warning. Well, that's never gone anywhere. People ask me, why don't you keep doing that? Why don't you do it? I don't care about it anymore. I don't really care about it anymore. But we have to get on the inside. We have to take legislators, lobbyists out to dinner, right? We have to do those things. We have to write legislative proposals. And we make changes, but it comes incrementally slow. Or you can leave. I've had practice, and the most dangerous situation I think right now for counselors probably is working in what we used to call Medicaid mills, where you're working for someone, you're seeing children, you're seeing a high volume practice, and they're doing something that is actually a felony, and you get wind of something that's not right, and you make sure your note's right. And at some point, you might want to leave that practice. You still might have to come in and testify as state's evidence later. I've talked to people who have done that, but at least you got out and maybe documented what you thought was wrong and confronted someone. I've seen some awful situations with that. Even a colleague of mine that was a real good practitioner who the only mistake he made was when he left a group practice somewhere, he didn't terminate his Medicaid number with them, and then they continued billing, and he didn't find out about it until the IRS audited him about a year later, and he got this huge tax bill from the federal government saying, you know, this is how much we have on your income, and he didn't know about the income because it was going to his tax ID number. I mean, how many hospitals out there have my tax ID number? Some of y'all can't remember your Social Security numbers. And I can remember 3 of my federal tax ID numbers, but not the other 2. My corporate and my personal, I always remember those. But you know, a lot of hospitals out there have those. You can look them up on the internet. So if you have a Medicaid number and somebody's billing on it under your tax ID number, that's fraud. This is a lot more common than it used to be. Then you're responsible for that, right? legally. So that's a thing to be careful about, leaving a situation. That's the kind of thinking that comes up on the CPCE. Oops, sorry. Malpractice, the 4 Ds: duty, dereliction, damages, direct cause. Be careful what you put in writing about someone. I don't ever say anything in an email that I would not want the Attorney General reading, because I know high-tech clients that do read those things in agencies where they're monitoring stuff like that all the time. I never use Gmail. I would never communicate anything about a patient in Gmail. I would never, you know, because I don't own the information. Google does. Yeah, don't do that. Slander. You don't have many cases on state boards on this. You have more related to negligence or unprofessional conduct. Those are more common. Misdiagnosis. That's one where we're going to have more counselors probably getting called for that, because now that counselors do have a state law that allows them to make a diagnosis, it means that is an area in your practice that you need to be addressing with every single client you see, because under your licensing act, you're allowed to do that. And if you're not doing it, then why aren't you doing it? Presents a conflict with the ACA ethics code, because the ACA ethics code allows you to see people without diagnosing them. But what if you're doing career counseling with someone who has a serious mental disorder? You've got to be able to diagnose that. If you fail to do that, there's liability attached to it. Then you're going to be held for a finding of wrongful diagnosis. Just like psychiatrists, that's a big area for psychiatry, and a little bit for psychology. And we never saw counseling before, but we're going to start seeing some of those. This is the cost of defense. You have to have malpractice insurance. Yeah, you do want to do that. You ever been served with a $10 million federal lawsuit? Yeah, fortunately, you got the whole state of Georgia behind you, and you got the Attorney General's office. But if you have a malpractice policy where your limits are $1 million or $3 million, then the rest of that's got to come out of your pocket. But what if you don't even have that? What if you don't have insurance? That's very, very dangerous if you're a practitioner. Your average payout is probably a little bit less than $25,000, which is different than the cost of defense. Okay, cost of defense is how much it's costing CNA to defend the claim. The payout is usually less. They try to keep it under $25,000 so it's not reportable to the National Practitioner Data Bank. You don't want to be paying that money though. Your insurance company too, people sometimes forget that their liability insurance company is a good place to get a consultation. They'll have an attorney. The attorney doesn't know the state law where you're practicing necessarily, but they can help you with things. And it's good to have that documentation, because then if you get a complaint filed later, your insurance company's already been advising you on how to handle things. So that limits your liability and increases the likelihood they're just going to bring somebody in and help you out with it. But also have a local lawyer for that. Feels like this might be a little bit too legally oriented. You can get a NCE question on that type of thing that relates to liability. Kind of an overview though. Is any of this relevant to you? Since you haven't had it in a while. Yes, ma'am?
Well, they have questions about like the legal precedent. Have they had them in the past?
You know, the ones you're likely to see would be having to do with things like HIPAA, FERPA, and we'll talk about some of this in the law section. Jaffe v. Redmond, Tarasoff, those kind of things come up. Bradley has come up before. It's the only Georgia case that would ever come up on a national exam, but it hasn't come up in a good while now. Tarasoff and Jaffe are probably the only ones that really have much of a likelihood. The Donaldson case actually in Florida comes up sometime. Keith Donaldson, guy that was held against his will in a state hospital for so long, and then took like 15 years to get him out. And the United States Supreme Court had to make a decision on it. That's in your books, though. I think you're ready for a self-care break, which I assume is different than a break. So thank you so much for your attention today. I appreciate it. You're what I live for these days, the future.